Hi, good afternoon, everybody. I'm going to introduce the people that are here with us today. Today, we have a number of attorneys with us from Greeman and Toomey. It's a Social Security disability firm located in Minneapolis, Minnesota. It's one of the largest Social Security firms in the nation. They handle a significant volume of cases, definitely one of the top firms in the nation. And we work with them, and I'm honored to have them as one of my referral sources. And with us here, we have James Greeman, Patrick Toomey, Ryan Miner, all attorneys with the firm. Good afternoon, everybody.
Hello. Morning, Brian.
Afternoon. Good morning.
Oh, it's good morning by you, right? We're coming on afternoon here by me, different time zones. So I wanted to talk to everybody and actually record this meeting because it's been a hot button topic that I've been going over with other attorneys, and I know we had this discussion and we wanted to talk about it a little bit. So I'm going to record this meeting and to let other attorneys also hear what I have to say on this topic, because I think it is a hot button topic, something that's coming up across the nation, and it's something that I really think other attorneys and representatives need to pay attention to when it comes to the time to cross-examine vocational experts at the hearing. So one of the main issues that we're dealing with more and more now is when you have an opinion or an RFC that ultimately gets created where you have a limitation to occasional contact with others, specifically coworkers and supervisors. The issue you run into is that occasional contact with supervisors and coworkers is the type of limitation that could preclude the ability to get through a training period, also called a probationary period. And it's kind of important when you get to step 5, when you're at the point when you're questioning the vocational expert and you have a situation where you know that the ALJ is going to be placed in a position where it's likely they're going to be finding occasional contact as a limitation. You may know that because the medical opinions may have that limitation in there, or the ALJ may have already asked a series of questions in the hypotheticals incorporating occasional contact as a limitation in the questions. But when it comes time for you to ask your questions, it's important in this situation to ask the question of whether or not occasional contact with supervisors and coworkers would make it impossible for an employee to complete the training period. Now, how you ask the question is ultimately up to you. It doesn't have to be involved. I've seen very involved cross-exam, especially from you, James, on this topic, and expertly done, in fact. But even if an attorney or a rep asks a series of questions on this topic, and it doesn't have to be as expertly done as you do them. Sometimes 1 or 2 questions is more than enough to get this issue across. Because if you're asking the question, if it's impossible to complete or will be difficult to complete the training period, if there's a limitation to occasional contact with supervisors and coworkers, more often than not, an honest vocational expert will actually admit that it's not possible to complete the training period. And that's going to create a problem and a catch-22 for the ALJs. They don't generally like having to deal with this. Now, they do have workarounds that they can do to try to get around this, but it's very hard. And the reason why it creates a bit of a catch-22 is because normally the occasional contact limitation is tied to a medical opinion. And the medical opinions will usually say occasional contact, period. Occasional contact with supervisors, occasional contact with coworkers. Sometimes they'll have a superficial contact limitation in there. But what the ALJs do to try to get around this issue is they sometimes create an RFC that's not consistent with the medical opinion. And the medical opinion, most often than not, would have been found persuasive on this point. And they try to create a workaround where the RFC will create sort of a dichotomy between the social contact limitation both before or during the training period and after the training period. So for instance, an ALJ might create an RFC that says frequent contact during the training period, but occasional contact thereafter, or something along those lines. Well, that makes no sense because the doctor did not opine to any split. There isn't a split in the medical opinions. No, I've never once seen a medical opinion where a doctor said the claimant can have frequent contact during a training period and occasional contact outside the training period, because it makes no sense. People don't operate that way. People don't have, greater limitations during a training period than outside the training period. It makes very little sense to have that kind of a dichotomy. That creates a bit of an error, an argument for an error, because the ALJ is trying to get around that issue that you've just created through cross-examination. But in doing so, they're creating an RFC that is not tied to any medical opinion, and there's no accurate and logical bridge to that RFC. So just by asking the question, a lot of times you're creating a reversible error, because the ALJ is now bending over backwards to create an RFC to get around the very issue you've just raised. And in doing that, they're creating an RFC that has an error. That's one way they do it. Another way they do it is they turn around and they just create an RFC that just straight up says frequent contact with supervisors and coworkers. But when they do that, most often than not, it's not tied to a medical opinion. Usually a medical opinion will say occasional contact. So then the ALJ has to bend over backwards to create a rationale as to why frequent contact is appropriate. And that sometimes also creates a separate error. Other times they'll just create the RFC out of whole cloth, saying, either frequent contact during the training period, occasional afterwards, but yet they found the medical opinions to be persuasive. And you have no idea why this RFC was crafted in the way it was. But the bottom line in this is that the reason why this is an important line of cross, even if it's a short line of cross, I think it's the type of line of cross that you would ask everybody, just as if you were to ask the time off task limitation question, right? It's a one question item. How much time off task would an employer tolerate? Now it's on the record, right? If an ALJ didn't ask, most of the time an attorney or rep will ask that. I think this line of questioning should be that type of question, just added in to everything, because it starts to create that error where none would have existed before, and it creates a problem for the ALJ. And the ALJs really struggle to get around it. So I actually have seen a few decisions where the ALJs did an okay job of trying to get around it, but there was still an error. Like there was still an argument for an error that we took. So it's really a tough situation. I've talked to some attorneys throughout the country who have been trying to implement this line of questioning, and the general feedback that I've received is that by and large, the attorneys then start just getting yelled at by the ALJs. Counsel, I know what you're trying to do here. You can't ask those questions. What are you doing? That's the type of line of scolding that gets reported back to me and across the country. This isn't just one jurisdiction, but apparently it is a hot button issue to the point that the ALJs are aware it puts their back into the corner. So my recommendation to you guys, and I know you have a high volume practice and you do a lot of hearings, is to add it into your hearings, and this will help us create potential errors to address down the road if the ALJs can't properly handle this. And my guess is they're not going to properly handle this quite frequently. And for anybody else watching this video, I strongly recommend to everybody that you add in at least one line of questioning asking about whether or not it's impossible for an employee to complete a training period if they're limited to occasional contact with supervisors and coworkers. So VEs will answer this question differently. I've seen VEs which will answer the question of just straight, they'll be honest. If it's occasional contact with supervisors and coworkers, no, you cannot complete a training period. I've seen VEs say, well, if it's occasional contact with supervisors and coworkers, it's okay to have occasional contact with supervisors because realistically, it's the coworkers that do the training. But occasional contact with coworkers is going to be problematic. And then if that's the limitation, you can't complete a training period. And I've seen another way is I've seen VEs just fight you on it and say, no, occasional contact's fine. But that's a much more rare situation. That's a VE who I think is more advocating a position. So I find that that's rare, but I've seen it happen, and that creates a bit of a tough situation. But an honest VE who's not advocating a position, I think will give you an answer that you can work with. So based on all of that, and since we're here to talk about it, do any of you have any questions or comments based on anything that I've said so far?
Well, I just have a quick comment, Attorney Toomey here. You're right. If the VE is honest, they will just answer the question honestly. Every once in a while, you do get the VE. Well, what do you mean by occasional? What do you mean by superficial? Well, these are very unskilled jobs. You can learn the job within an hour. So I do get pushback from some VEs with that line of questioning. I haven't had any difficulties with judges kind of criticizing the line of questioning, but I think it comes down to the VE. If a VE is honest, they are going to give you an honest response. If the VE thinks he's advocating on behalf of the administration, he's going to dig in his heels and find a reason why somebody can learn that job, even in the context of occasional and superficial.
Yeah, I agree. That's been my experience too. A lot of the VEs just will honestly answer, but every now and then you'll get some pushback. And just like you said, the pushback will be, oh yeah, you could learn this job in an hour, or it's not really going to take 30 days to learn the job. It's going to take 1 day. It's a simple job. But I think those are just VEs that are advocating a position, and they think that they're supposed to give favorable testimony that'll make the Social Security Administration satisfied somehow. But that's more rare. Most of the time, you're going to get favorable testimony on this point.
Well, and what would you recommend? So when we do get the VE that says, well, this is a job that you can really learn in an hour. It's a very simple job. What do you do to further question them?
Well, I think then the question is going to be, but during that hour, they're going to have regular and consistent contact with this coworker and supervisor. They're not going to learn it in 10 minutes. If you're telling us that it can be learned in an hour, then they're going to have regular and consistent contact throughout the entirety of that hour. If somebody has problems with social contact, is that a problem? And then if you're in a situation where you have superficial contact limitations, then I think you can strengthen that line of argument, because there's no way in an hour you're face to face with somebody going through details, step by step, because that's what you're doing at that point. It's going to be much more than superficial in nature. And a lot of times you'll have a superficial and occasional as the limitation. So just double check what your limitations are that are opined to, and you might be able to leverage that. And, because if you're learning it in an hour, you're going to have somebody standing right next to you during that entire hour. That's much more than superficial.
I have some input on this in response to Patrick's question. This is James Greeman speaking. What I've experienced is that the VEs almost invariably testify to occupations that are SVP of 2. And the definition in the DOT for SVP of 2 is that it takes up to and including 30 days to become proficient at the job tasks and duties of occupations that are SVP of 2. Very seldom, in fact, extremely rarely do you ever get a VE testifying to SVP of 1 occupations, which are the occupations that can be learned on short demonstration. If they testify to SVPs of our occupations that are SVPs of 1, that would be the way to defeat this line of questioning, because, well, it's short demonstration, Mr. Greeman. I'm just showing you, take this object, stick it in the hole, take the finished product and put it in a box. There's nothing more to it than that. It takes literally less than a minute, 30 seconds to teach this person how to do the job tasks and duties of this occupation. But they don't testify to just SVPs of 1. Like I said, rarely. So SVPs of 2, up to and including 30 days to learn. If you have looked at the DDE, the SAMC opinions, where they indicate that the contact can be occasional, then you have a lot of firepower on your side at that point, because the judge has to overcome that SAMC's opinion. He's going to have to reject it. And of course, we all know that the judge has to consider that opinion. And then they get into this problem where they piecemeal it or cherry pick the opinion, say, well, I agree with this, but I don't agree with occasional. And then they say, well, the person can do frequent without any reference to any supporting documentation. So if you have occasional from the SAMCs, and the VE has testified to an SVP of 2, you got them. Because the VEs will come back and say, when I ask them, you agree that this occupation requires more than occasional interaction during the training period. And I'm actually quite a few questions in at that point. But when they say no to that question, you can come back to them and say, but this is an occupation's SVP of 2. And you agree that that takes up to and including 30 days to learn. Yes. And then they'll say something like, well, the training period is only 10 days long, or the training period is only 2 weeks long, or the training period is only a few days long. And then what you do is you come back on that and you say, well, you testified to occupation A, B, and C. You haven't gone out and done an evaluation, an assessment, or an investigation of how long the training periods are for individual jobs within occupations A, B, and C. No, I haven't. And that can vary from employer to employer. Yes. And that could be up to and including 30 days. Yes. and you don't know how many jobs for the occupation A, B, or C that you testified to that would take longer or up to and including 30 days to learn the occupation. No, I don't. And so, there's, to the point about pushback from VEs, the more you ask the same VE these questions, the more they tend to push back. If you catch a VE that you've never questioned before or has never heard this line of questioning, I agree with Pat. They tend to answer the question honestly. But I've had VEs who I've done this line of questioning with, numerous times, and they're getting more and more resistant. They dig in ever more. And that's on top of the judge jumping in and saying, counsel, where's this going? Counsel, that's asked and answered. The typical tactics that the judges use to interrupt your line of questioning. The typical subterfuge that's engaged in these hearings that everybody listening to this, if you've done, more than 100 hearings, you know exactly what I'm talking about. And there's a lot more to say about this, but I'll stop right there.
Why do you think the VEs who become accustomed to that line of questioning seem to become less honest? Seems to be what you're saying, right? They are more honest if they're not used to this line of questioning. But then if you have either questioned them repeatedly on this in the past or others have, then they start giving you more pushback and fight. Why would they start switching up at this point? Any thoughts?
I think that could be multifactorial. I think it could be they feel, this is really cynical, but I think that some VEs feel like they're an advocate for the agency. That could be the reason. They may have been talked to. Look, there's evidence that VEs have had conversations with HOCALJs or even individual ALJs. I've been told that. I've heard about investigations being done about that very issue. I've had retired VEs admit that to me. I've had hearing assistants tell me that there are conversations that occur after the attorney and the claimant leave the room, and they talk about the case sometimes. And I'm not going to name ALJs and I'm not going to name VEs, but so I think that there's that, and that's at the one extreme end. I think that another factor could be very innocent in that they've never heard the line of questioning. So the first time they do what Pat said, answer the question honestly. But as they hear the question more, they think about it more. And as they get asked those questions more often, they tend to contemplate it more. And so I think that those are two potential reasons why there may be more pushback. And I think sometimes too, VEs get emboldened by when the judge interrupts. I experienced this last week in a federal court case remand that you did, Brian, where the judge kept jumping in on me, and it just emboldened the VE, and the VE's tone got snarky. It was combative, arguably, and of course that gets turned around on me, and I get told I'm being combative when the VE is the one that's being non-responsive or, in fact, just outright hostile. But of course, the VE is never admonished. How many people on this call have ever heard a VE admonished by a judge? It never happens.
Never seen it.
So I think it's a line of questioning that ends up being fatal to their hypothetical. When a judge puts in occasional contact with coworkers and supervisors, it's very difficult when you engage in this line of questioning with the VE after that initial hypothetical, and it's usually the first hypothetical, so that's the least restrictive, is posed to the VE, then you can just kind of go at it with them. And I think it becomes very difficult for them to defend it. I had one judge, when I first started doing this line of questioning, switch up their hypothetical and literally editorialize as the ALJ was doing it and said, fine, I'm not going to limit the claimant to occasion. I'm going to limit to frequent during the first 30 days of employment. And I objected. I said, objection, judge, what's the basis in the record for that? That's like saying somebody's limited to light work, but they could lift 50 pounds during the first 30 days, but now they're only able to lift 20 pounds without any support in the record or any reference to any place in the record that the record establishes, that very strange RFC.
Yeah, there's no logic bridge to that. It's just made up out of whole cloth.
It's made up. And I even have said to the judges, Judge, you're just making that up at this point. There's no basis in the record for that. That's just made up to defeat the line of questioning that I just did with a vocational expert. And I literally say that on the record. And they don't like it, but I've made my record and they know that I'm not going to back down on this issue. Sometimes they can overcome the problem if they limit the claimant's contact with supervisors to frequent and with coworkers to occasional. Then the VE will come in and cite 3 different occupations, a number of jobs for those occupations, and say then when the line of questioning is engaged in that the person who's doing the training is the supervisor, which doesn't make a whole lot of sense. I mean, even in our own law office, yes, do supervisors do some of the training? Of course, but most of the time it's a coworker. It's a coworker who already is versed in the job tasks and duties of the job tasks and duties that this new person is learning. And that sometimes is an issue too. They'll sometimes say there is no orientation or training period for a new employee. And then you have to go down a different line of questioning. And, you got to be careful about it, because you can sound like you're being kind of sarcastic yourself and saying, well, when the person arrives at work, what do they do? Just start working? Is there any orientation? Is there a handbook? And some VEs will say that, well, there's a handbook that they read, or there's a video that they watch. I use the phrase job shadowing. And I'll ask the VE, are you familiar with the concept during an orientation or training period that you just conceded that this person would need to go through to learn the job tasks and its duties? Yes, I'm familiar with the concept of job shadowing. And for the record, you would agree that that would be a situation where an experienced person who knows how to do the job tasks and duties of the occupation is teaching a person who doesn't know how to do it, and they're literally sitting next to each other. That person who's being trained is following that person around, watching them do their job tasks. Questions are being asked of the person that's being oriented or trained to the person who's experienced, and then there's interaction between those two. They're discussing why what needs to be done at a given time is done, and why it needs to be done a certain way, and the timeliness of it, and just the aspects of carrying out the job tasks and duties. So you can see that it's beyond superficial, and it's also likely going to exceed occasional, because most people aren't going to be able to get trained in 2 or 3 hours for an occupation that's an SVP of 2 that takes up to and including 30 days to become proficient at. So there's lots of different directions that I've seen these VEs take this. In other words, I guess what I'm saying is that they've figured out defenses to this. And I'll even call the VEs out and I'll say, Mr. Smith, it sounds like you're advocating for the agency. It sounds like you're making an argument on behalf of the commissioner here about the idea that these occupations don't require any orientation or training. And, various responses are given back. No, I'm not doing that. And I'll say, well, then you just testified that you have gone out and seen each of these occupations and you've observed the training for each of these occupations. Why would you do that? You wouldn't normally do that for an occupation. That seems like a strange thing for a VE to do. And maybe not, but some of the VEs have said, I don't go out and observe the training period. The ones that have will say, yes, I went out and I looked at job A in my responses to the hypothetical, and I've seen that occupation's training period, and it's only 4 hours or 5 hours one day. And I'll ask, well, you testified to 40,000 jobs for that occupation. How many jobs have you seen a person getting trained at for these 40,000 occupation or 40,000 jobs within that occupation? I've seen one. You haven't seen that person be trained within the last 5 years, though, have you? No. And the reason I use 5 years is because 5 years is the past relevant work definition now. And I think Social Security changed that definition of 5-year look back because of the advent, institution, and utilization of technology changes so fast that jobs are arguably changing that quickly. So those are some of my thoughts and some of the things that go on in my head about this line of questioning. But I don't disagree with you. I think it has to be done. I question whether 1 or 2 questions about it is sufficient, though. And let me comment about that, and maybe you can respond. But if your idea of 1 or 2 questions might preserve the argument for appeal, I'll go on for 10, 12 minutes at times with the VE. We'll get a denial on that case that I did that very extensive cooperative line of questioning with the VE about the training period. And if the judge were to accept it, the claimant would prevail because the limitation in the judge's hypothetical was too occasional, and he didn't give a less restrictive RFC. But when you read the decision, it's as if that conversation never happened. There's no 1.5 or 2-page discussion about it. It just says vocational expert said that this person could do the occupations in response to the first hypothetical, and it completely ignores the line of questioning that was done. That's another way that the judges get around these points. They're just playing the odds.
Right. They try to get around these points a lot. As for the issue of whether 1 question is sufficient or not, I mean, I've seen your crosses. I am very much aware of how thorough you are with your cross examinations, and I recently read one where it was expertly done, and it drew out the whole scenario of how training works and why it has to be more than occasional under the circumstances. However, by and large, if I'm talking to attorneys across the country, myself, I can't teach everybody to do what you do, right? You're obviously an expert cross-examiner. Not everybody's an expert cross-examiner, but I need these questions asked. I need the issue to be preserved. And if I'm going to be explaining to people that this issue needs to be addressed, sure, each individual attorney and rep is going to have to figure out on their own how to follow up if they get a combative vocational expert. Right. I can't teach how to follow up. Every attorney is going to have to think about it and come up with that process on their own. But to start this issue and preserve this issue, I need it done by and large by attorneys across the board with at least that one or two question to get it out there. And a lot of times that one or two is enough to preserve the issue and get a favorable answer. But again, that may be different from your approach. And I understand, I've seen your approach, and your approach is very, very detailed. But I need, aside from you and your abilities with your cross exam, I need every other attorney and rep out there who needs to ask these questions to get at least those questions out, one or two questions, so that this issue is preserved and so we can attack it at the federal level.
Brian, a question about what you just said is, does that kind of put it back on the judge then if you just ask one or two questions and there's now an issue raised? Does that kind of put it back on the judge pursuant to Social Security ruling 004P about identifying an inconsistency?
Well, it should, but they're not going to address it. I've never seen a decision where the judge addressed it at step 5. It's always ignored, which is one reason why I've asked your firm and pretty much every other firm I've ever talked to that if you've addressed this issue through cross-exam and you send the case for us to review, please note it when you send an email over, because I'm not going to know it's there. I may not listen to every audio recording that comes through, but if you've asked it, flag it for me, because the ALJ is not going to flag it. They're not going to address it. They're going to ignore it and just say the vocational expert testified that the claimant can do these jobs. That's going to be the end of it. You're not going to hear anything else.
Right. In my post-hearing instructions in our case management system, we happen to use Prevail. I would imagine a lot of listeners do too. I give detailed instructions and flag cases where that questioning was done, where it's appropriate. They don't always give limitations like that, and it's not always appropriate to give a limitation to occasional. But in situations or circumstances where that is done, I'm always trying to flag it. And I think you're getting, when we send over cases for you to review, the ALJ decision and the appeals council, or the ALJ decision, we're always sending over a narrative saying, hey, this is what happened during the hearing. At least we should be. If we're not, let me know off the record here.
No, you guys flag it now. It's because we've discussed, outside of this discussion we're having here that's recorded, we've had this discussion, about this before, and you flag it and have it flagging it for us when you send things over. But by and large, because the ALJ will never address this at step 5, and they just basically ignore it and just, address it and say, vocational expert testified that these jobs can be done, and that's the end of it. When I'm reading a decision to do a merit review, I'll never know this question was asked because the ALJs aren't going to touch on it. So that's why I ask both, your firm and any other firm, if this question has been asked, and especially if the question has resulted in a favorable answer, then I may need to listen to that testimony, and you need to flag it.
Ryan, do you have any questions, any input on this?
So everyone's been pretty much getting into what I would have added at this point. Well, the only thing I would add to this here is the one method I've seen, the most unique method I got of somebody trying to get around this line of questioning. I don't know if you saw this one, Brian, or not, if you got to this one. The vocational expert was trying to define occasional basis on the entire week, not on the workday, not like in a 1-hour period, but would define it over the entire week. So the idea is that a hypothetical individual could still have occasional contact for the supervisor to get the training done, and then be occasional rest time, because it'd be like the whole workday, but it's all within the first workday that they did. That's how they would try to avoid that line of questioning, which I found that to be really that bending of things right now. And I think that's more of an extreme way of how they come about that. But how do you define what's an occasional period? Because are we breaking it down by days or a week or whatnot? But that was like the most egregious egregious that I wanted to share that I've experienced. So
I would say occasional is, cumulative total of the time that they're in their training period, which could be on a daily basis, could be on a weekly basis. But look, if a person can't interact with another individual more than occasionally, I think you can distill it down to the sort of that granular level of one work day.
I think that's the most reasonable or prudent way of approaching it. It's like each workday, because we discuss a person's strength limitations is again based upon a daily basis. You're standing up to at least 6 hours, an 8 hour day, sitting around 6 hour to 8 hour day, et cetera, et cetera. So we would assume that, but then we start talking about attendance issues. That attendance can have that great variety of what that is. So,
and Ryan, I get your point about what you're saying here. Sometimes the vocational experts will say, they'll be incredulous, or they'll feign that they don't understand the question. They'll say, "You mean they can never have more than occasional contact with a coworker or supervisor?" Yes, occasional means just what I said. It means no more than a cumulative total of 1/3 of an 8 hour workday. In other words, I mean what I say, and I say what I mean.
It's 160 minutes.
And I found that's why you need to lead the witness a lot. You can't really ask open-ended questions. If you ask open-ended questions, most vocational experts are skilled enough to just run with the answer, run with their answers, and they'll start talking about irrelevant things, and they eat up all your time. So don't ask open-ended questions. Lead as much as you can, as much as that's uncomfortable. Maybe not for people on the East Coast, but for most people, even attorneys, it's uncomfortable to tell the witness or the person you're talking to what the answer is. And that's what you're doing. And a lot of times the judges will interject. "Well, counsel, you're testifying." Judge, a good attorney leads an expert witness. And Mr. Smith can answer questions. He's an expert. He's subject to being led. "I'm going to proceed now," or "May I continue?" And then they back off. They understand that you're not wrong. You're correct about that idea. One other thing that I've seen is that the vocational experts will say that it doesn't take 30 days to become proficient at the occupation. And I'll say, well, this is an occupation that's an SVP of 2. So your testimony seems to be inconsistent with the DOT and the SCO, because the DOT says that it does take up to and including 30 days. Well, not in my experience. Well, in your experience, how long does it take? 2 weeks. Okay, so during that 2 weeks, you agree then that a person would have more than occasional interactions with a coworker or supervisor inconsistent with the hypothetical at times. Yes, I would, counsel. And based on that strict limitation to no more than occasional interactions with a coworker or supervisor ever, even during the 2 weeks, this person couldn't do that occupation because they can't get through the training period. I agree. And you agree that getting through a training period or an orientation period or becoming proficient at the occupation is a prerequisite to keeping the job. Yes, I do. And if a person cannot keep the job, they cannot work on a regular and continuous basis, can they? No, they can't. Thanks, Judge. That's all. And again, the way they get around it is they just ignore those questions and they deny your case if they're going to deny the case.
And that kind of questioning that you just gave an example of, that's why those are the types of questions that attorneys need to be ready to think about on their own, right? Because I said to preserve the issue, you ask 1 or 2 questions. But if the VE is battling you, right, the sample and the example you just gave, that's the type of more long-winded, long-tailed kind of stream of questioning that flows from that you will do, and other attorneys and reps will need to be, find proficiency and be able to do as well. Because it's one thing to ask 1 or 2 questions, and it may work a lot, but if you get the VE that's going to fight you on it, then any attorney or rep watching this is going to need to know how to do a line of questioning, just like the example you just gave. In fact, I suggest anybody watching this who sees that sample line of questioning you just give should probably write it down and keep it aside somewhere, because these types of things happen.
That gives me an idea, Brian. Perhaps as an adjunct to this recording, you and I could do a brief role playing where you're playing the VE, consistent with my experience with most VEs come along with the testimony, but I'll do my typical line of questioning, and then perhaps you can role play as the VE and answer the questions typically how you hear them on the transcripts when you're seeing this line of questioning that I engage in. I think that'd be helpful for people. I think the other thing too is that as attorneys, as advocates for our clients, we got to get used to the idea that we're there to do a job. We're there to represent our client. We're not there to make friends with the judge. We're not there to maintain the peace. We're not there to, have the vocational expert think that we're a good guy or not step on toes or, embarrass people. I think you can do this line of questioning. I think you can be very assertive with it. And I think you can be very respectful in the line of questioning. There's lots of techniques you can use. You can slow down your questions. You can lower your voice, but still be very assertive and seek the answer that you want through leading questions. But I think this idea of not cross-examining witnesses, that can't happen with what we're doing. The agency considers this a remedial and non-adversarial process. That's the spirit of it. That's maybe even the letter of it. But the way that it's actually done, if you have listeners that have done, more than a handful of cases, they realize that they've had a client that's gotten screwed over by the way that the expert testimony was analyzed or way that, the other evidence was analyzed. So you have to be ready for putting aside any hesitation that you have about asking these questions, even when the judge is right in your face. I have a lot of stories about this, but I've had judges come in mildly and say, well, question, counsel, that's asked and answered. Respectfully, judge, it's not. Well, rephrase your question. And then you rephrase your question, but you got to be able to go on your toes. You got to be able to be on your toes. I've even had judges, outright accuse me of, badgering the witness or harassing the witness. And I think this is beyond the scope of this conversation, but threaten me with sanctions or threaten me to be reported. And that's just bizarre at that point. And of course, I'm not doing anything that's a reportable offense. It's just they don't like the fact that I'm being an attorney. I had numerous judges say, I've never heard a lawyer ask these questions. And my response is, Judge, that's really unfortunate for the claimants across the country if you have lawyers that just simply sit on their hands. We can't do that.
Yeah, and my view is if you're asking the questions, you've got the floor. You're the attorney, you're the advocate. The ALJ cannot just interfere with you, but they do because they're under time constraints, and it really pushes the envelope of violating due process. Unfortunately, the case law is not overly favorable in a lot of those arguments, but it's really bothersome because in any type of other practice area, in a courtroom with a jury, you wouldn't be curbed nearly as much as you are in this practice area.
Well, and that's disingenuous on the parts of the ALJs who do that. And we all know who they are. They're the ones that schedule 45-minute hearings. They schedule 6 or 7 hearings that day. And even if you might have 3 or 4 hearings with that same judge, they're constantly hustling you through the hearing. We're out of time, counsel. You're encroaching on the next hearing. And, you can say, well, the next hearing is my hearing, judge. I'd rather have a fair hearing than a fast hearing. And I have more questions. So, well, then we're going to have a supplemental hearing like that's some kind of punishment. And I said, my client is fine. Yeah, my client is fine with a supplemental hearing, judge. And sometimes the judges will even ask my client, I'll say, Your Honor, it's not appropriate to ask my client whether they want a supplemental hearing. That's a question between me and my client. And I'm representing that my client wants a supplemental hearing to finish the line of questioning. And they'll almost invariably grant it. There are some judges that will literally at the beginning of the hearing tell you, you have 10 minutes to present your case. Or when you're questioning the VE, you have 3 minutes, counsel. And they kind of create these artificial timelines. And then you set up this kind of straw man argument and, say, well, we only have 45 minutes for the hearing and you're now encroaching on violating that time limit that I've applied. And I think a lot of times it's done to try to curtail your questioning because you are getting traction with the vocational expert. You are making points that they're going to have to decide how they're going to deal with in the decision.
Yeah, if they do it all and instead of just ignoring it like they usually do and just pretend you never asked the question.
Right, which is common.
So does anybody else have any questions on this point or comments?
I don't, Brian. And again, I think with the VE testimony about the occasional and superficial interaction, like you say, just a couple of questions out there, get it on the record, establish your argument.
I think at minimum, I ask everybody, you got to get the argument down. You got to ask at least a couple of questions. And James' point is very well taken that sometimes 1 or 2 questions may not be enough. So, my suggestion is that everybody, no matter who's watching this, any attorney, any rep should ask a question or 2 on this point but think about it and consider the issues because there may be a VE out there who's not going to be so easy to deal with and is going to not give you the answer you want. and you may have to follow up. So in those situations, more than 1 or 2 questions are going to be necessary, but that's, a case by case situation. I think every attorney, every rep who sees this needs to really consider, what the next steps are going to be, what the next questions could be. And there's plenty of examples just in the content of this video.
The case that this is partly predicated on, I didn't necessarily get this line of questioning from that case. It's called Shapansky out of the Second Circuit. And so people should familiarize themselves with that case. Shapansky, Zepanski, I believe. But I've even had judges who interrupt on the first question that I ask about the limitation to occasional with coworkers and supervisors. When I ask the first question of the VE, the judge interrupts and goes, "Counsel, I know exactly what you're trying to do." And my response is, "You mean represent my client? Ask the vocational expert, the neutral witness, questions about their testimony and about the hypotheticals?" "Yes, Judge." "Then you obviously know what I'm doing." "No, I think you're trying to demonstrate that occasional doesn't get you through the probationary period or the first, 1 month or the orientation period or however it's referred to." I think Shapansky talks about the probationary period. But so they'll try to do that. I also understand, I've heard that new ALJs are now being exposed to this line of questioning, that this is a line of questioning that attorneys are doing. And this is before they're even christened an ALJ. They're being taught this at judge school, that this is an issue that's coming up in hearings and that they have to be prepared for it, which makes it seem like they're actually sort of collectively defending against lines of questioning, which is, I think, very questionable. But
no, I think that's exactly what's going on. This issue is now becoming more and more of something I see all across the country, where you have that kind of dichotomy in the RFC, where it's frequent contact during the training period, occasional after the training period. This wasn't something that you would see very frequently before. More and more, even over the last few months alone, this is coming up all over the place. So it's not uncommon any longer, and it makes it look as if judges talk and they have these discussions and conferences, and it's become more of a nationwide thing. And I think it's just going to keep growing as an issue.
And I will add this, lest the listener thinks that this doesn't happen. I've been doing this kind of law as an attorney I'm in my 31st year, but I've been doing this since 1990. I had, I think, a very honest ALJ, and I would say most judges are very honest, but I had this ALJ take me aside about 25 years ago and say, the ALJs in this particular office, we send emails around about the arguments that you're making in hearings, and we have conversations through emails about how to defend against your arguments. And I said, well, that sounds kind of collusive. And, the judge had no comment, but that was corroborated by a couple of other judges when the conversation came up over the years, or that issue came up, that judges absolutely talk and they absolutely discuss the arguments that are being made by attorneys and how to defend against those arguments.
I have no doubt.
Which makes me very sad about our system. But regardless.
Right. Well, it's a system that we're in, and that's why people need attorneys, right? You shouldn't go do this alone. You need an attorney to help you, which is because, this is the system we're in. It's not easy. It's not an easy system, and it's you've got ALJs. They look for ways to get around these arguments, and unfortunately, some ALJs go out of their way to look for reasons to deny claimants.
Mm-hmm.
This is the world we live in. So this is why we are all here, and why we all advocate for our clients the way we do.
Yeah. Well, thanks for putting this together, Brian. It was nice of you to get us together and have a conversation about this, because I think too often we're not doing what I think the ALJs are doing sometimes, getting together as a group and just being really blunt about the issues. There's NASCAR and NADER, and those are great organizations, but they're limited, I guess, is what I would say.
Well, I definitely appreciate that you all met with me today. And, if anything else comes up where we need to get together and talk, I'm always available. We always have an open door policy. I suppose if that's it for today, I'll shut down this meeting. And if you guys need anything else any other time, you know where to find me. Drop me an email, give me a call.
Yes, sir.
All right.
Thanks, Brian. Thanks, Ryan. Thanks, Patrick.
Thanks, Brian.
Thanks, everybody.
Take care, all. Bye-bye.
Signing off.